Hello everyone, we're back and we want to talk today about beneficiaries versus heirs. It's so important because you always hear someone on television, they say, okay, I'm an heir or I'm a beneficiary. There's a huge difference. If you've been following the videos, which I hope you have, if you haven't, go back and listen to them in order, and that way you'll get a better understanding on the procedures of trust estates and probate court and how to stay out of it, as well as conservatorships. Okay, so a beneficiary. A beneficiary is a person named either in a will or a trust, and they're the person who the creator of either that trust or will is leaving their estate to, their assets to. So what's the difference? Okay, well, if you're a beneficiary in a trust, which a trust we know is private and it does not have to go to probate, there won't be any discrepancy. But if you're a beneficiary named in a will has to go to probate. So you're no longer a beneficiary, you become an heir. And you have to prove your heirship. Wow, you can be named in the will, but you still have to prove it. They're going to ask for proof of who you are, your birth certificate, how you're related, those type of things. So the difference between being a beneficiary, once you're named, those assets in that trust can be distributed to you because of the protections you have in a trust. But since a will has to be probated, you're no longer a beneficiary. You may be named, and you are named, but you become an heir, meaning that you have to prove your relationship to the person, that you are who you say you are. So it's a different ballgame because now it becomes a legal proceeding. So that always opens up the floodgates for fights because someone can say, well, I was left out of the will. Even though they can say they were left out of the trust, there's not going to be any fight over that. But if they say they're left out of a will and you're in probate court, there ensues the fight. So even though you're a beneficiary named in a trust or a will, once the person in the will passes away, you're no longer a beneficiary. You become an heir, and you have to prove yourself. Let's talk about one quick case of heirship. So we know when Prince passed away, they said he didn't have a trust. So you have all of these people coming saying they were his children, long lost family. And what happened was they had to prove, so that's why they're still in court, many of them. They have to prove that they were heirs and how they were connected to this person, and that this person, Prince, would have wanted them to actually have a portion of his estate. So that's the fight over heirship. So when you hear the word heirs, that means usually there was not a will, there was not a trust, or even if it was a will here in California, it still has to go to probate, and you have to prove yourself either way in a will. I don't know how it is in your state. It might be different, but I can say for certain here in California, wills have to be probated, and that's why it's so important to know the laws of your state. Anything can happen to any of us at any time, and we may think that we're passing something on, and we find out that there's a big problem. So on the focus that we have, we're talking about beneficiaries versus heirs. So a beneficiary is named in either a will or a trust. If you're named in a trust, there's not going to be any discrepancy about who you are because trusts are private. They don't have to be probated. But if you're named in a will, especially in California, in many other states, you're going to have to prove who you are because you're no longer a beneficiary, you become an heir. Also, if someone dies without a will, they don't have anything and they have assets, a home, various pieces of property, cars, jewelry, artwork, bank accounts, and they die without a will, that's called dying intestate. that has to go to probate, and you have to prove who you are to this person, why they would have wanted you to have any of their assets. And usually it goes in order. If there's a mom or dad left, if there's children, so it goes in order, then cousins, nieces, and nephews. So there is an order it takes. But the point is that a will has to go to probate. And if you die without a will or a trust, it goes to probate. So the best protection would be a trust, because you become a beneficiary. A beneficiary is a person who is designated to receive a portion of the estate or all of the estate. So there may be several beneficiaries in a trust or a will. If you have a trust, there's not going to be a problem. There's going to be distributions more likely than not. If you have a will, it's going to be probated, and you have to prove who you are. You have to prove your relationship. You have to prove that this is your ancestor. You have to prove that you're the descendant of this person and what relationship. I think that's pretty much it in a nutshell. It's clean, it's clear. An heir always has to prove who they are. A beneficiary in a trust does not. So that is pretty cut and dry. I hope you rewind this video, take notes, and leave a comment in the comment section if you have any questions, and I'll more than happy be able to answer your question. Thank you again for watching this video. I really enjoy doing it. I really enjoy bringing this education to you. It's so important because so many people are unprepared, and this will help you start thinking about it and getting yourself prepared. I look forward to speaking to you again in the near future. I'm going to bring you some more educational videos in the same line, working with trust estates, conservatorships, fiduciary business, and I'll talk with you soon. Thank you so much, and take good care. Have a wonderful day. Take care of your family now. Bye-bye.